Alors, bonjour tout le monde.
Thanks for coming out again today. Some of the panelists might be speaking in French, and I might say a few words in French myself, so I just thought I'd remind you that you might need those gizmos, for lack of a better word. My name is Gabrielle Saint-Hilaire, and I'll be chairing this panel, the last panel of the symposium this morning. I'm a professor of law in the French Common Law program here at the University of Ottawa with a focus on taxation and tax litigation. But I also teach basic corporate law, and that's my connection to the subject of the symposium today. And it is giving me an opportunity to think about what it is that we teach students, either in the Faculty of Law or business or in some of the social sciences classes as well. So I just thought I'd say a few words about what we might be thinking about in a basic corporate law course. And I know some of the members of the audience today are lawyers, but not everyone is. But we will ask ourselves in a basic corporate law course from the get-go, what is a corporation, and why do we set one up, and what is the political, what are the political reasons for allowing people to set up corporations and allow them to do what they do. So students quickly learn that a corporation is a person separate from its shareholders, but that's a legal fiction, because we can't touch the corporation, we can't see the corporation, and like Professor Glasbeck said yesterday, the corporation is this thing. And I'm not going to ask you what it is that you saw when he drew the corporation for you in the air yesterday. But, the corporation is a person, and it can do anything that a physical person can do. So it can contract, it can borrow money, it can hire and fire people, and as we all know, it can kill. And as Professor Toombs said yesterday, with impunity. So, having that set the stage, we eventually, in the course of talking about corporate law, with students, we talk about corporate liability, and we talk about tort liability, we talk about contract liability, and how we can get corporations to pay. And we also ask ourselves, do corporations ever really pay? In light of their ability to transfer their costs to, first and foremost, their employees, but also to their clients, their customers, and also to the community and the public at large in various forms, through lower wages, through workplace tragedies, through higher costs for the customers of their businesses, and for the community as large in terms of bankruptcy, eventual bankruptcies, and that sort of thing. But we eventually come to the subject of criminal liability, and that's when I always used to get extremely nervous in teaching corporate law, because I'd ask myself, what am I going to teach students about what we do within the common law to address corporate crime? And how I'm going to teach them about these doctrines, which I'm not sure I truly understand, and how, in the end, I don't think they really work. So I was quite excited when the criminal code provisions or when we added the criminal code, the new provisions on corporate crime in the code, thinking, oh no, I thank my lucky stars, now I have something I can teach to students about how we're going to address corporate crime in Canada. And then I waited, and it's as if nothing happened. And I thought, well, it's not really my area of research. I do tax more than I do corporate law, so maybe I just don't know. But I waited, I read what I could, and nothing happened. So I basically started telling my students, I think the criminal code provisions are like a decoration, something that's nice to have, nice to look at, but that doesn't really serve any real purpose. And that may be what prompted Corey Willard, from whom you've heard yesterday, take up some research on that issue, because together we question, why is it that C-45 hasn't had the impact that we thought it would have? Why have there been no prosecutions, no convictions? So we heard yesterday about some of the challenges that the prosecutors face, that the police face, and that other actors in this debate face. So the task of this panel, amazing panel, is to explore the political challenges, the political challenges that were faced by the proponents of criminal law to address the issue of corporate misfeasance in getting the legislation adopted. What were the challenges faced? And to ask ourselves, what are the political aspects that contributed to the provisions receiving so little attention and so little use since its adoption 8 years ago? And we need to look at what is the political will we need to go forward. And we also hope to hear about the importance of corporate criminal liability legislation in the context of transnational corporations. So I'd like to introduce the members of our panel, and I start with the first person on my left. Penelope Simons is an associate professor at the Faculty of Law at the University of Ottawa, and she's been engaged in research on corporate human rights accountability since December '99, when she participated in a mission to Sudan to investigate allegations of slavery as well as links between oil development and violations of human rights. Penelope's current research is focused on the human rights implications of domestic and extraterritorial corporate activity, as well as state responsibility for corporate complicity in human rights violations. So Professor Simons brings a transnational perspective to our discussion today. And to her left, I hope I've got my right and my left together here, we have Mr. Duff Conacher, who is an internationally recognized leader on democratic reform and government accountability, and is a former Ralph Nader Raider. He is a board member and was the main founder of Democracy Watch, and has led the organization to secure changes to legislation and to government policies. And he has authored or co-authored over 40 government and corporate responsibility reports. I think more currently, Duff is the director of goodorg.ca Consulting, which provides advice and services in the areas of good governance, ethics, and responsibility to those who want to hear them. And on his left, we have Mr. Andy King, who is currently a Master's of Law student studying under the supervision of Professor Catherine Lippel. And most recently, he'd been the Health and Safety and Environment Department Leader for the United Steelworkers Union. I think he's got a lot of friends in the audience. And prior to that, a criminal defense counsel in private practice. Andy has done inquests involving workplace deaths across Canada. He was one of the steelworker staff involved in the campaign to amend the criminal code to address corporate criminal negligence, and is therefore very familiar with the political challenges that were faced by people working to get the provisions or the bill passed. And finally, on his left, nous avons Maître Marc Bellemare.
We have Marc Bellemare. He's a lawyer for the City of Quebec, has a long experience, and he was a Minister of Justice and Auditor General of Quebec. He pronounced conferences on the law, on the insurance, automobile insurance, and the victims of the highway. He presented in front of the Bar of Quebec and the Association of Chiefs of Police the question of the health and safety in the workplace. In 1984, a decade before Westray, Maître Bellemare appeared in front of the commission, parliamentary commission, to comment on a bill in accidents in the workplace, and appeared in front of several commissions. He represents now members of the families of individuals who lost their lives in the workplace.
Is going to adopt the same format as we have adopted with previous panels. So panelists, I will ask you to provide a 2-minute opening statement regarding your perspectives on the issue of corporate criminal liability legislation generally, more broadly, and or on the Westray bill more specifically? Penelope, might we start with you?
Okay. Thank you very much for the invitation to be here. As Gabrielle said, I'm going to be speaking about this issue from a transnational perspective. And I'm going to talk about it in the context of extractive industry. So I just want to kind of, in this 2 minutes, just lay the basis for my comments that I'll make later on. First of all, obviously, extractive industries are very important to Canada. We have 75% of the world's largest exploration and mining companies that are domiciled here. And of these companies, approximately 70% of those operate overseas, many of them in developing countries. When extractive companies go overseas, many of them end up in what we call zones of weak governance, which could include conflict zones or places where they're not going to be regulated. And they can become complicit in grave violations of human rights that amount to crimes or international crimes, often through their public or private security arrangements. There was a report that was put out by the Prospectors and Developers Association of Canada, PDAC, in 2009. It was a 2009 report, didn't come out till 2010 because they suppressed it. But that found that of 171 high-profile incidents in relation to clashes with communities and human rights abuses and other such things, that 34% of those were by Canadian companies. Canadian companies were implicated in 34% of them, and that Canadian companies were involved in 4 times as many incidents as their closest peers in Australia and the UK. Criminal liability for corporate complicity and extraterritorial human rights violations is important in the sense that it can offer a tool in a whole toolbox that would be set within a comprehensive regulatory framework to try and hold corporations accountable. But on its own, it's not really something that would deter these kinds of abuses, and I'll talk more about that in my further comments.
Thank you. Duff?
Thank you. I'm wondering how many, if you could stick up your hand if you're a member of Parliament or member of provincial legislature here in the audience today. Okay, so that's one political challenge. The other is that Canada's corporations spend $25 billion annually on their lobbying and promotion efforts. And on both the government side and the corporate side, we're essentially in a framework where all of this is discussed as a basis of cost of doing business. And in government, or in the corporate side, there's actually a whole practice in consulting on reputational risk. In other words, it's only about reputation. It's not about the business ending. It's not about not being able to do business anywhere in the world again if you as a corporate executive set up your corporation and run it in a way that causes harm of any sort. And as long as we have that overall framework of approach to these issues on the corporate responsibility standards and system we have, and only have a few tools in the toolbox, not all the tools that you really need to have responsible, ethical corporations. But also, as long as we have, on the political side, systems that allow for that kind of money to be spent on lobbying and promotion, which isn't paid for by the corporation. Of course, it's passed on in the prices for products and services. Or a system such as in Alberta, where one person gave the ruling party $430,000, 25% of the total amount that they raised during the last election. We are going to have serious political and also socioeconomic challenges to ensuring that all corporations act responsibly and ethically in everything they do, and don't just view it as a cost of doing business and a possible risk to the reputation.
Thank you, Duff. Andy?
Thank you. I think what I want to say to start off is that Westray was a failure on multiple levels. Over the last day, we've heard about it as a failure of the employer, egregious behavior that didn't take care of the basics of health and safety. And we've heard about it as a failure of legislation. Hence, we talked about the implementation of C-45. But sort of following along the same theme, it actually was a failure on a number of other levels. It was a failure of industry generally. I would remind you that a month before the West Ray mine blew up, the mining industry awarded West Ray the highest award they can for health and safety, the J.T. Ryan Award. It remains a tragic irony that one of the recipients died in the explosion. And that the industry, in fact, has never rejected Clifford Frame, the man who was the architect of the West Ray mine. Until recently, he was actually still a member of the Mining Hall of Fame, having previously won awards as Miner of the Year in '82. It was also a huge failure of government. There was a small reference to that yesterday, but this was a scenario in which the mine was inspected, but the mine inspector did nothing, and he did nothing because he understood that to be the policy of the government of the day. And that was certainly replicated by the statements of the premier of the province, who blamed everything on the worker. This fundamental problem of deregulation that gave permission to this company to do whatever they want was protected by law. The tragic irony of it is that when the West Ray families, the survivors, tried to sue the government for failure to regulate, their defense was the people who were carrying out the responsibilities of the inspectors were employees, and therefore, by virtue of the Workers' Compensation Act, the government was protected from any civil suit, following a number of other cases that the Supreme Court of Canada held. So in that context, I think we have to look at the strategies going forward, and what took place as things that are happening on a number of different fronts in a number of different places. So the change in the legislation was an important piece, but so are other changes that went on. The campaign to get rid of the Ryan Award was an important part of it. And I think what that says to me about what this event is about, and if I can put it in sort of building on the point that Duff just made, we may not have politicians in this room, but we have lots of people who do lots of very important things. And if there's one thing that could come out of this, is that if the people in this room, just one small thing that's relevant to moving this forward, in whatever place you are, if you can do one small thing based on what you picked up today to contribute to that moving forward, we've accomplished the purpose of the symposium, and things will move forward. Because it is the actions of people in many places committed to move and to make an improvement that will, in the end, enable us to move forward against these overwhelming circumstances. Thank you.
Thank you, Andy. Marc?
I'd like to congratulate the organizers to have had the excellent idea to look at the C-45 8 years later. I was at the time Minister of Justice of Quebec when C-45 was put forward by Martin Cochon, and I was there also when the law was adopted in March 2004. There were two objectives that were the aim. All governments in Canada were happy that this bill came through. Well, the first objective was that the directors of companies could be brought to justice and be convicted. And it was also the perspective of incarceration, of being jailed. So those were two fears. There were two new elements that were not of the jurisdiction of provincial laws, where there are only fines that are levied. But it changed the whole framework of the industry in Canada. So it was a disaster. And 8 years later, we have to understand that C-45 would have permitted given the politicians the opportunity to make a gain by brandishing the perspective of the possibility of incarceration and of course, the Minister of Justice cannot do more than just present a bill and have it adopted. So it's the judges, the police. So the judges never really pronounce themselves because the Crown has never laid accusations because the police never made any investigations. So there you go. And in Quebec, there are explanations because we have the impression that the workplace is a kind of a ballpark reserved to the employers. It's like a hockey game. Why Pacioretty wasn't selected? No accusations against the guy who nailed him in the boards because the police does not intervene in hockey games. Well, we feel like the workplace where there are fatalities and serious injury, it's as if it was the skating rink of employers in Canada, and police does not intervene in such. So when there is a fatality at Hydro-Quebec in Quebec, the police calls the inspectors of Hydro-Quebec for an investigation, for internal investigation. And when there's a workplace accident, the police calls the CSST, which administers the laws of inspections, who makes the investigation. And very rarely, very seldom will the police involve itself when it's a workplace related, when it's a crime. A cashier who's been stabbed in a convenience store, the police would intervene because it is a crime with a pointed weapon. It is a standard crime. But when it is a workplace-related crime, well, we feel like it's not. There will be a fine levy. There won't be any accusations. So there is an institutional problem that is a society problem that is not only under the government's responsibility, but these laws. I will put an end to my intervention on the fact that the population in general is not does not acknowledge or is not aware of the industrial crimes. I defend the victims and their families of workplace-related accidents for nearly over 30 years. And people are surprised that for the neighbors or the friends, oh yeah, he died in a workplace-related accident. Inherent risk that he assumed working there. So we trivialize this type of crime in the population. We will be scandalized by a crime with a knife, sexual assault, domestic violence. But when it is a crime at the workplace, we feel like the population is not really aware of this. There's a fundamental societal perception of this type of crime, so there's a lot of work to do for several people.
Merci, Marc.
Thank you very much, Mark. And I'd like to thank all of you for your...
I'd like to move now to a more specific question, and that is the question of what were the political challenges faced by those who worked hard and for a long time to get Bill C-45 enacted. And perhaps we could start with you, Andy, on this.
Well, in many ways, the key political challenges are the ones that have been referred to now, and sort of this general idea that death at work is just what happens. It's an acceptable cost. It's a normal occurrence. It's not a problem. And I think if you were to summarize all the different things that were done by different people in different places, it was all about denormalizing it by saying that this isn't normal, this isn't right. And the key elements of that, I think, have been explored, and I'm just going to quickly summarize them. Steve Toombs talked about the importance of survivors, organizations, and family members, putting the human face on it. Vern Theriault, who spoke last night, coming to Ottawa to actually confront the legislatures with the reality of what happens in these circumstances was a key part of it. I think the other part of it was just to move people within Parliament. We were fortunate at that time that we were able to find a few members of Parliament who were prepared to take this on. And they took it on initially as a private member's bill, and that gave the opportunity for those organizations who supported this to sort of get behind that and gave us a sort of a perch from which to push forward. There was always an undercurrent of resistance, but it was often not very public by the companies. Because, of course, the companies didn't want to come out, the representatives didn't want to come out and say, look, it's okay for us to kill people. Right? It just wasn't going to fly. Not even, in fact, I would argue even today, well, okay. It's just not an argument. And so, it was the Director Chill, right? We're never going to we won't get people of quality to be on the boards of directors because they're at risk of being held criminally liable. My thought was that was actually what the whole point was, but apparently not. And so I think that from the various things that we did, it was all about focusing on people and players who could make a difference and to denormalize, to say this is not right. And one of the best and most unknown campaigns was to demonize, and I don't think there's a better word, the person who was responsible for it. So I mentioned Clifford Frame, who was the architect of all of this, who was personally responsible for the death of the 26 miners by any rational method, who continued to operate. He tried to open a coal mine in Australia, or buy a coal mine in Australia. He did so in the US. And every time he did, there was a very friendly Dean Job, who at the time was a reporter in Halifax, would send us a message. And so we'd contact people we knew in Australia. We'd contact people we knew in the US. We even contacted people we knew in Russia when he tried to work there. And at the end of it, I am pleased to tell you that if you Google his name to this day, the first thing that comes up is the Nova Scotia government says Clifford Frame will never operate a mine again. And that, I think, is another part of the piece, is that what I was saying earlier, it's people doing multiple things. And I just want to end by saying that when I hear, from yesterday's panel in terms of what people are doing, I'm thinking particularly the work of prosecutors, the work of police officers to try and, without a lot of support, there are still people doing this. I think that's another example of how this moved forward, is that people are trying to do the best they can to move this issue by recognizing it's not okay to kill under these circumstances.
Thank you, Andy. Dov, do you want to weigh in on this question?
Just a little bit, because Democracy Watch only played a very supplemental role to all of these efforts. Really just the push through Parliament after the bill was introduced, and all we were trying to do, one was we organized a corporate responsibility coalition and got more than 30 groups together from other sectors other than labor to show that there was broader support for these kind of changes, but also took the opportunity before the committee to talk more broadly about how this was just one tool in the toolbox and how many other tools were needed. And the main thing we highlighted, and I've been highlighting for the past 20 years, is that we don't have enough individuals organized into organizations that are broad-based, well-resourced, self-sustaining, independent of government or corporate funding, to really penetrate a lot of these issues and reach enough people so that you can make them realize, because they're not exposed to it personally day to day through anyone they know, that these are the realities in workplaces and these are the difficulties that are still there. And I just want to mention this idea in case I don't have another chance to, which is an idea we've been pushing for 20 years. It's very simple. It would cost government nothing, business nothing. But business is very, very effective at figuring out how to bill individuals. They've figured out how to do that very efficiently because they want to collect payments for what the products and services they're providing. And so they send out envelopes with the bill inside and often a return envelope. It's a brilliant system. Now they're doing it more electronically. And what we've pushed the committee to do, and have pushed many, many committees to do, federally and provincially over the past 20 years as Democracy Watch, and with the Corporate Responsibility Coalition and another coalition we organized on bank accountability issues, is a very simple idea, which is piggyback a pamphlet from a citizen watchdog group in the billing envelopes that business is already sending out. So, just to give you one example, banks mail out to about 25 million Canadians a credit card bill or a bank statement every month. If once or twice a year, there was a pamphlet inside that invited people to join the bank watchdog group, they reached 25 million people at a very, very low cost. Very low cost, less than 1 cent each. So for essentially $250,000, you can reach 25 million people. If only 4% responded and gave $40 each, you'd have 1 million people join this group and $40 million annually come in. That changes and balances the marketplace in a way that it's never been balanced other than by unions. So these are citizen unions, and we need them, and unions need them as well, because of this divide where people don't really realize, because most people don't work in these industrial situations or other workplace situations. And although they would be more consumer-oriented, they would still be connected in with the whole costs of doing business and how that's imposed on individuals and how the corporations and corporate executives reap the benefits. Again, an idea that costs nothing to do. These days, not only would the pamphlet go out, but a notice would be put at the top of every email that goes out to customers and to shareholders, individual shareholders. Anywhere there is mass billing or mass notices sent by business, this method can be used for mass organizing. So you board a plane, you're handed the pamphlet to join the airline watchdog group. You go to a lumber store, you're handed the pamphlet to watch over the whole forestry industry. You go to your food store, when you're checking out, you're handed the pamphlet to join the group that watches over the food industry. It's a generic method developed by Ralph Nader. And if we had it in every sector, we would have a very different consumer and worker marketplace, and that wouldn't be so much corporate-driven, would be much more citizen-driven. So that's a longer-term challenge, and that's the kind of thing that Democracy Watch really brought to this whole policy process and have to other policy processes, is that if we really want corporate responsibility, we have to have organized consumers and individual shareholders and citizens, not just workers.
Thank you. Marc, est-ce que tu veux commenter sur les défis politiques?
Would you like to talk about the political challenges that you experienced at that time? Yes. We've associated C-45 with Westray. We've called it the Westray Bill, or the Westray. Perhaps that was a mistake, because it was a dramatic event in Canadian history. 26 people killed by a mine explosion. But when we associate the law with an extreme event, in the minds of many people, that trivializes many other kinds of events that aren't things that should be excused and are just as dramatic. Are we waiting for a second Westray before we can come up with new accusations? Perhaps there'll never be one. There are other kinds of crimes that haven't attracted the attention of the police, of the Crown, of governments, and nor of general public opinion. But I share my friends' opinions on the importance of making the population aware of the existence of industrial crimes and the importance of sanctioning them, of creating punishments for them. In Quebec, there was an election on September 4th, and the government was proposing $53 million for an asbestos mine and to invest billions of dollars in modernizing a nuclear plant.
Alors, heureusement, ce gouvernement n'a pas...
Luckily, the government was re-elected, and the government was elected did not go along with investing in asbestos or in modernizing the nuclear plant. But it's 2012 now, and there have been demonstrations in the streets with people who wanted the nuclear plant to be modernized, and they wanted investments in asbestos. These are two sectors that are internationally recognized as having high levels of cancers and death rates are very high. There's been a lot of very conclusive research done in those two industries have to be abolished. Nuclear and asbestos industries have to be done away, but there are people who think that it's important to invest in these industries because they create jobs. Again, we're trivializing the risks. What does that mean? It means that when we think that it's related to work, it doesn't matter. He was paid for that. He died. It was an accident. I'm sorry. So it's not quite as serious. And C-45 came in that framework, in that context, in 2004. Or is it only Westray accidents that are important that should be covered by C-45? There are lots of people who think that's true. And that sort of explains why there weren't more accusations or police inquiries. Personally, in the files that I'm involved with in Quebec City as a lawyer, I can no longer count the number of cases where I have written to the directors of criminal prosecutions in Quebec with inquiry reports and asking him to prosecute under C-45. I've done it 10, 15 times, and there's never been a result. In 2007, I sent a letter to the director of criminal prosecutions to ask him to prosecute an entrepreneur who had dug a ditch and a worker. The work was badly done, and a worker was buried in that. I wrote to the criminal prosecution director to say the manager has to be accused. It's easy to dig a ditch. If you do it in your backyard, you have to have slanted walls and etc. And no one will be killed. Yesterday on television, I was watching the news from Montreal. There was a report that came out in a similar case. A worker was killed. He was buried alive under the ground. The family demanded compensation. It wasn't a mine where 26 people were killed. There are simple cases in which the inquiry report decided that there is gross negligence that endangered the life of a worker, but nothing's happened. It's scandalizing to me, but what more can we do to write to the director of the Crown in Quebec and ask him to prosecute and demand reports? There's a lack of will. It's as if the whole industrial sector is left to the care of commissions and inspectors for health and safety, and they're going to put a report. There'll be no civil fault, no criminal prosecution. There's a lack of interest. So in Canada, as far as I'm concerned, it's total impunity. Employers do whatever they want, and there's no kind of legal binding measures that would prevent from taking risks with the lives of workers on work sites. Thank you, Mark.
Have not been used like we thought they might have been, or even in cases when it seems obvious, as in the cases that Mark just told us about, where it seems obvious that they should be used and that they were intended to be used in those circumstances. So I'd like to now move to the next question, or maybe I should say questions, because I'm trying to group the next two questions together. And the first one of these is, has the Westray Bill changed anything? Has it changed anything on how we understand and approach issues of workplace safety? And in combination with that question, I might ask you to address the question of why it is that the Westray Bill legislation was not and is not as significant a political issue as other types of criminal legislation. We often hear politicians speak to us about the tough on crime legislation, and that's in the media regularly. But we don't hear about this type of criminal legislation in the media regularly. So perhaps I can start with you, Duff, for this one. For these ones.
Yes. I'll stick mainly to the second question. And I think, first of all, Ralph Nader's, one of his favorite sayings is that there's much more attention paid to crime in the streets than crime in the suites, as he likes to put it. And I think really it's because the crime in the streets issue is one where politicians can push the fear buttons and hype the statistics in a way, as one famous phrase from a recent cabinet minister, Stockwell Day, was that there's lots of unreported crime, and that's why people should fear. So the statistics are wrong about the crime rate dropping because there's lots of unreported crime that somehow he knew about, and therefore, and everyone should fear this because it's out there. And it's difficult to do that with workplace crime, to frame things in that same way. So over time, you have these kinds of things build into the matrix, really, that we're all caught in. And there's no easy escape from this matrix. Most of what I did with Democracy Watch was focused on consumer protection, and another part of the matrix is to always focus and say, well, you know, we have the system that's you're a buyer, and buyer beware is the way it goes. And why? I mean, why is it not a system where it's seller beware? Why is that not the framework that we're in? So, with the crime in the streets versus the crime in the suites or the workplace crime, these frameworks have been pushed and pushed and pushed for a long time because I think of the entire political economic system, and when you look at how governments come into power, the strength of the corporate lobby, the threats that they put in place in terms of withdrawing from countries, moving businesses, and the other kind of threats like director chill and these kinds of things, and that no business will do any business in this jurisdiction, there won't be any investment if these kinds of things are implemented, along with the politicians trying to use the fear as a motivator for voters and focusing on street crime as a result, you end up with the focus simply being so much more on the street crime. And then, I mean, I could talk for a long time about the media and how the media also want to focus on that, and that those are stories, no matter where they occur, really, in the world. Those are stories in local media, again, boosting this fear of that we should fear each other more than we should fear what some corporate organization may do because of its way of it's structured and the way it operates.
Thank you. Alors, Marc, est-ce que tu veux nous parler un petit peu de comment...
Could you talk a little bit how you see this question, Mark? Has it changed something in your perspective, or would you like to make any comments on why this kind of legislation has received so little political attention? I do think that it changed the situation for a few years, starting in 2004. As long as employers didn't really know how C-45 was going to be used, there was an obvious fear on their part, and that had a deterrent effect on them. I remember that in 2005 and 2006, there were lots of colloquies with employers, chambers of commerce, and the employers' organizations that were concerned, and they wondered if they would be hosting the next X-ray, Westray. So I think that one of the next things that made the pressure go down was this case in Quebec. There was an accusation against a country called Transpavé. There was an accusation, and everyone who agreed with C-45 was happy until Judge Chevalier Well, there was a guilty plea. There was no trial. The media didn't really go along with that whole story about the death of the 27-year-old and the fault of the employer who had unplugged the safety mechanism. The employer actually caused the death. And he was forced to pay a penalty of $100,000. He said, the employer said that he was traumatized by the man's death and that he was sorry. And so he paid only $100,000. And yesterday, in my research, I found an article from Canadian lawyers, 2008, an interview with Martin Cochon, who's satisfied with the results. And I said, oh boy, he forgot the objectives from 2004. Perhaps he's defending his law. Previous minister wants to show that he was right, that it was a good law. Yes, he was right, but what's followed has been disastrous, and we cannot accept a $100,000 fine for death caused by criminal negligence. It's completely unacceptable, and I repeat that if the objective or the result of C-45 is just to come up with fines, that won't make it. The employers have plenty of money. They make money. It's a business that works very well, and it continues after the accident. It's not a deterrent. What is a deterrent is a criminal sentence for someone who didn't provide for security, and eventually a criminal sanction. If you kill someone with a car or with a knife or in a fight, you're going to have to do your time. And why wouldn't employers do that? And it doesn't. We wouldn't need much to be able to do that. We just need one case anywhere in Canada. And there are lots of examples. I see them every day. One example, an accusation, a trial, a conviction that can change the whole situation, and that's what we need. C-45 is an amendment to the criminal code, and that's basically it. Yes, it did have an effect because employers fear that they might eventually be convicted under C-45, but when we realized that there was no follow-up on the legal level, and finally the fines were very low, pressure was taken off them. Even though we have a very powerful tool with that law in our hands, we're not using it, and that fear has disappeared, as far as I can determine.
To give us his thoughts on whether it's changed anything or whether it's just a paper tiger.
I'm going to reframe the question a little bit, if I may, because I think it was clearly a step forward and provides us with some tools, but that, as Marcus just said, that we're still, even though it's 8 years later, still in the beginning stages of making this happen. So what I'm more focused on is making this happen. I mean, we have the breakthrough. We have the Metron case in Ontario. We've had the cases in Quebec. There's a struggle going on in BC. I think really what we need to grasp is that the problem is not with the design of the law. The law is designed in a way that can be used. And so one thing we need is more, picking up on something Harry said, more people theorizing on how it can work more effectively, just to support the work that's being done by others. I don't want to diminish that part of it, because while acknowledging we're in a political environment where the political support, right? When I practiced law, the thing I remember most is when Ian Scott, who was then our Attorney General, said, you know, it's not allowed anymore in this province for a husband to abuse his spouse and expect the charges to be withdrawn or not to be charged, which was in the 1980s still prevalent in this province. And he said it's not going to happen anymore. And he said the next time a Crown attorney pulls one of these charges, he'll be fired. And through with the Solicitor General, there were directives given to the police about handling these cases. There were special groups put together, you know, in order to carry it through. And in a right world, that's what would have happened by now, right? There would have been special groups formed within the police, special groups formed within the Attorney General's office to figure out how we're going to do this most effectively, now and ongoing, but it hasn't. So I think we have to keep pushing those pieces, though, so that we can transform it. So having heard yesterday from Vern Edwards as to what the OFL is trying to do, Nina Hansen talked about what the BC Fed is trying to do, what other organizations are trying to do. What I think's missing is the piece that's been raised by Duff, which is this is about people being killed at work, but it's more broadly about people being killed by corporations. And I find these days when I mention things like, is XL Corporation in Alberta going to be prosecuted criminally for releasing tainted meat on the population? Or what about the manufacturer of OxyContin, who knew that by promoting and lobbying government to use that drug, that people would become addicted to it and it would destroy their lives? Are any of those people ever going to be prosecuted? And why not? So we have to bring this, I think you're right, I very strongly believe that we have to bring these things together, both because on the one hand, as you've said, we need to recognize killing people at work is a criminal act. It's not acceptable. It's not just, it's got to be seen as something more than that. We've got to make that happen. On the other hand, it's not just workers. It's everybody who intervenes, has an interaction with the corporation, which means, of course, most of us. And the key thing there is trying to continue these struggles to build the broader links and to influence people in the different places where that can make a difference. So I'll just end my comment by a little project that I worked on with Corey for the CLC, which was to try and develop a plain language guide on C-45 for the police. And, the way it was done was predominantly by Corey was consulting with police officers in Ontario and elsewhere, all informally, just to get what do you need? What are the questions people are asking? How do we deal with that? We need to do the same thing with prosecutors to provide them with support, but it's all a part of a pushing it forward kind of activity. And a linking of that to the broader issues that are here. It's not going to happen on its own for reasons that have been described yesterday and today, but I don't think it's a failure. I don't think it's a paper tiger. I think we're still in the process of making it work, and we've got to keep going to the next step. When, the crime in the suite is the crime that we're all concerned about ending because of its impact on all of us.
Thank you, Andy. Penelope, do you want to weigh in on this?
Yes, I think I can say a few words about why Bill C-45 is important in the transnational perspective. When you get out to companies that operate overseas, Canadian companies that operate overseas, there are very few mechanisms that are available to govern their activities, especially if they're operating in what we would call a weak governance zone. So, and the other problem is that international law itself treats transnational corporations as these disaggregated entities. So it doesn't treat it as a corporate group, it treats it as all these separate legal entities, so the parent in Canada and the subsidiary or joint venture partner in Colombia, for example, as separate legal persons that are supposed to be governed by the states in which they operate or incorporated. So the host state should regulate the company that's in Colombia, the company that's there, and the parent, and Canada should regulate the parent company. So there's that problem. There's also the problem that even if corporations commit what are considered international crimes, there's no international tribunal to actually take jurisdiction over those crimes and prosecute them. The International Criminal Court doesn't have jurisdiction over legal persons. And even if they did, they wouldn't have sufficient resources to go after corporations. So having domestic law then that makes it easier to attach liability to a corporation can be important. The other thing is that, in terms of the lack of regulation, is that we have a lot of transnational and intergovernmental, what I would call self-regulatory initiatives like the Global Compact and the OECD guidelines, the IFC performance standards that are often spoken about by corporate management as if they're going to regulate the corporate actions and that they're sufficient to kind of govern the activities of these corporations when they operate overseas. But they're not. And, you know, they've been proven to be completely inadequate for doing that. And in fact, if we're looking at human rights issues, they don't even govern to a great extent human rights issues, at least not the IFC performance standards. And similar conclusions can be made about other kinds of domestic mechanisms that we have, like corporate transparency laws or even transnational human rights litigation in terms of providing some sort of effective means of governing corporate criminal behavior that happens in the transnational context. And no state has yet enacted a comprehensive, targeted regulatory framework to ensure that when their companies operate in other countries that they don't become involved in human rights abuses. And so, as I said before, I don't see criminal liability as the as a kind of silver bullet, but I think it can be an important part. And then when we talk about the next question, I can talk about this of a comprehensive legislative framework that specifically targets that kind of conduct.
Thank you, Penelope. So perhaps we can now turn to the last question that I'll put to the panel, and we should think about what it is that we do moving forward. What do we do now, and what are the political obstacles in the implementation of corporate criminal legislation? Andy started to address this question, and other panelists as well. So maybe we can give you each a few minutes to give us your thoughts on ideas moving forward. Perhaps I can start with you, Andy.
Sure. Well, first of all, I'm going to do something, or not do something, that's very difficult. I'm not going to talk about the Westray Bill anymore. Let's talk about corporate criminal negligence. And let's get to work on talking about what that is and why it's important to us in as many different applications and places as we can, how we understand it, how it should work, and in particular, how it should work from a from a point of view of the law being applied. And going forward from that, I think if we build on what we've heard talked about here, we've got some examples of prosecution, we've got some people who are working on this and thinking on this, and sort of try and develop that further. I keep wanting to make this last reference. I had the privilege when I was in the practice of law to practice with a lawyer by the name of Diane Martin. One of the last things she did before she left practice and went to teach at Osgoode Law School was worked on a case to try and see if it was possible for the Canadian government to intervene in the continued legal incarceration of Leonard Peltier, the Native leader who was wrongfully convicted and, as far as I know, is still unfortunately in jail. Out of that experience when she went to the law school, so I'm going to talk about where I'm home right at the moment, was the creation of what emerged in what was called the Innocence Project, something I'm sure many of the people here know. And that is that by working with other lawyers and with the broader community groups that were supportive of these issues and bringing law students and others to work together on the project, she began and recruited into that other people to work on exposing where people had been wrongfully convicted. And that, as most of you know, has moved forward from that into a much bigger operation in which many people have now been released, and we have, I think, a very different view. It's improved the standards, it's had an impact. And I think that's what we need to really think going forward from here. We've made some progress, but if the different perspectives represented here and others can come together and think strategically as to where we can add some more thought and practice into corporate criminal negligence, I think we can start the process of moving it forward. For all the reasons we've described, it's not going to be easy, it's not going to be tomorrow. But I do think the fact that the impact of the political agenda today, one of its impacts, particularly around deregulation, is we're going to see more and more of these cases where people are injured, made sick, and otherwise damaged because of unrestrained corporate behavior. And I think that provides us with a place to intervene.
Thank you. Marc, tes perspectives pour l'avenir?
Mark, please. I think the first obstacle, political obstacle, to implementation of C-45 is the lobby of the employers, obviously. First obstacle. The employers, they're almighty. They have entries in all levels of government, and it's the main obstacle. Next to the employers, there's these unions, the workers' unions, don't have as much clout. And another obstacle, I believe, is we have the impression that by working, we assume a certain risk. In other words, the governments, the politicians promise jobs, not necessarily safe jobs, just jobs. That's the mantra. And once you have a job, well, safety is another thing altogether. It's not a reflex, neither with the citizens nor for the political body. And another obstacle is this perception, which is still prevalent, that when an accident happens in a workplace, it's forcibly the worker's fault. There is actually, in Quebec, there's a advertising on TV and all media, newspapers, which focuses on workplace accidents, preventive type of advertising. And every time that we present this ad, we see a worker that is injured or killed, and we see his wife sobbing, we see his children, and we see the guy at home with a cast on his foot. Never, never, never is the message said that there's an employer who didn't do. It's like a taboo. The employer is never at fault. It's like something out of the imagination. It's out of the public discourse. And Ms. Lippel was saying earlier, in the law for workplace accidents, there's the fault of the worker that can disqualify him from compensation, whereas we don't have this tort notion for the employer. We have it in C-45, but it was never put into practice. So I believe this is an obstacle, and maybe C-45 should depersonalize. We should talking about a mind. Where we see this comes from, we should stop using that it be broadened. We have to cover other cases than mines. And if we search for the political obstacles, we have to ask ourselves, which would be the reactions if tomorrow morning in a Canadian province, a head of government, a head of a party, if I'm elected, I will prosecute the employers who commit crime in the workplace. Do you think this would be an interest, that this would be a stake in the elections for all the reasons I've just given? Well, we can't stop. We've got to continue. We have a tool. The day where somewhere in Canada, a Crown attorney will lay accusations in virtue of C-45, it will change the whole framework. So we'll bring it back to the surface. We have to create pressure on the police and the crowns. I think the law is there, the tools are there. It's a question of interest, judiciary interest at this point. Thank you.
Say a few words about this issue in the context of the corporations who've become complex multinationals.
Yes, thanks. So there are a number of things that happen when you look at this issue in the extraterritorially, and I'm not talking about workplace accidents per se. I'm talking about international crimes that corporations may become complicit in, so they're not actually usually perpetrating them. An example would be, for example, Talisman Energy operating in Sudan, where it's the airstrip of the consortium of which it was a part was used for offensive bombing raids that were that were against civilian populations living in the area in order to forcibly displace them. The government would then send in the ground troops to clear the villages, burn them, loot, abduct women and children, and there would sometimes be used helicopter gunships as well to shoot at them, all to protect the oil infrastructure and development areas from potential rebel attacks. So they were targeting civilians. So this is the type of crime. There's another Canadian company called Anvil Mining. Well, it's actually an Australian company which has an office in Canada that was involved in providing logistical support to the Congolese military in the eastern Congo, and the allegations against them in a civil suit go beyond that, saying that they didn't just provide trucks and airplanes to bring the troops to the place where a massacre was committed, but they also drove the trucks, drove the victims to places where they were executed, summarily executed. So these are the types of crimes. So it would be, if we were going to prosecute them in Canada, we would have to use the Crimes Against Humanity and War Crimes Act, and only 2 prosecutions have been brought under that act against individuals. So the chances of it being used for a corporation are very small, and that is, of course, a big problem. The other thing is that this type of criminal litigation or criminal prosecution is very expensive, requires human and financial resources, and the Canadian War Crimes Unit is notoriously under-financed. It's very difficult to produce admissible evidence, particularly where the acts are committed in the context of a conflict. So if you're trying to establish some sort of causal link between the acts of, say, Talisman's subsidiary that owned the shares in the joint venture, the Greater Nile Petroleum Operating Company, if you're trying to establish that causal link between the parent company and that is very difficult because of the complex structure of these transnational corporations. You know, in the case of Talisman, there were 5 subsidiaries in between the parent in Canada and the subsidiary that was a partner in the joint venture in Sudan. The burden of proof is very high in criminal cases, and there's also political reticence to bring these cases because of comity of nations and also foreign economic policy. So I guess that's probably all I wanted to say about some of the obstacles. And the other thing is trying to prove that the company was complicit in criminal terms. So they aided and abetted what the actual perpetrator did. Can be very difficult to produce credible evidence in that regard.
Thank you. And a few words from you, lastly, Duff, on this issue, please.
Thank you. I'll focus on domestic changes, capacity building, what legal changes I think are the most winnable, and then also strategies on how to win them. Domestic, even though I think if we increase capacity enough domestically, it will help enormously on the international level, but it's very, at the international level, it's a whole different ballgame of chasing after perpetrators. It's enormously difficult because really there isn't international law, let alone law enforcement. So in terms of capacity building, now we're turning again to this idea of the pamphlet or notice being sent out by business. If you want to see more information about it, the website's democracywatch.ca, and it's our citizen association campaign. If every union in Canada joined together and pushed for this idea to have these citizen unions formed, again, at no cost to government or business, the capacity that would be increased, because what would happen is 5% of people concerned about banks would join the bank watchdog group. A different 5% would join the airline watchdog group. A different 5% would join the food watchdog group. Each of them, you'd be talking about 10 million to 20 million people and 5% of those joining, so you'd have multi-million-dollar budgets created and broad-based groups made up of voters who are self-sustaining, not reliant on government money, which most citizen groups are that are advocating in any area. And that would balance the marketplace in many, many ways, including the policy process given again that corporations are spending $25 billion in that arena, Canadian corporations pushing their agenda. In terms of other winnable things, I think whistleblower protection is one of the most winnable, and that there has never been a coordinated effort by not just unions but all interest groups working all together for whistleblower protection, which is a system that really doesn't cost anything to implement. It's just a legal rights system. If it's, I mean, there will be a cost if it's a full protection system, but those costs will be covered by the savings you'll save in any corporation or government just by reducing waste, let alone harm. So and there's just really no argument against it that someone who's at work should have to even think about any consequence and to be reporting wrongdoing in the workplace. I mean, so Democracy Watch won 110 changes to federal and provincial law over 18 years when I was coordinator. And I was the only staff person, and we had an annual budget of about $60,000 on average. Because we always push things that 90% of Canadians agree with and that people arguing against them sounded stupid, because there was just no valid argument against it. And so the other thing is disclosure of lobbying is, I think, entirely winnable. There's actually a recommendation from a federal committee where there's a majority of Conservatives right now to reduce some of the loopholes that allow for secret, unethical corporate lobbying right now. That shows you how winnable it is, that this committee made up of Conservatives majority have made these recommendations. Not all the loopholes will be closed. And one of the big things that should be disclosed, which it is in the U.S., is how much corporations are spending on their lobbying effort, or any registered lobbyist. Because that's part of breaking down the matrix that everyone lives in and thinks that, well, corporations are out there providing products and services for us. No, actually, they're charging a lot extra to push an agenda, and we don't know how much they're spending on that agenda now, but it is required to be disclosed in the U.S. And again, something very winnable that would be a significant step forward.
So, Duff, if you'll allow me, I'm going to stop you here. This is the point at which I'm supposed to turn the discussion over to you, and I must say that I'm not a very good timekeeping police, so we're running a bit late. Perhaps we'll take 2 questions, and then we'll just roll right into the last part of the symposium, which is the synthesis and discussion with Catherine and Stephen. Go ahead.
Hi, it's Pat Van Horn. I just couldn't let this all go without mentioning the fact that, well, the Steelworkers were the lead organization when we were lobbying for Bill C-45 in the first place. We're also, and in conjunction with what the CLC is doing, we have initiated what we're calling a national campaign, but it is not a federal campaign. It's a campaign to put pressure on attorneys general in every province to do the political thing. Now, people were complaining last night that there weren't enough federal politicians, although we had sent invitations out to them who came to the reception. But it's the provinces where we have to focus now, and that is to make sure that attorneys general, who are all elected, are in a position that they must instruct their crowns, their prosecutors, their police to enforce this law. So we've never given up on the Westray bill or the corporate criminal negligence law, if you want to call it that, and we're going to continue to work in the provinces to put political pressure on attorneys general. I just wanted to mention that, so it's not a question. Thank you very much.
Thank you. Andrea?
So I just had a comment and a question, and part of my comment was I find the consumer stuff quite interesting, but I'm not sure in some cases how effective it could be. I don't think, like for instance, the bank watchdog thing, I don't think banks are seen as big evil corporations, although I firmly believe they are. until you have this sort of Darth Vader-like figure. And what Andy mentioned about sort of achieving a C45, that was created, right? Here's this person, this is what they did, and whatnot. And one of the question I have is that I think that trade unions have been helpful often at characterizing these, Darth Vader type figures, and using them as a way of saying this is unjust, and corporations shouldn't be allowed to kill with impunity. And often that's centered around the victim, and I take quite strongly the point that Steve Toombs made around, using victims' families. But I've noticed that what we can do at trade unions has changed since we started working with police and crown attorneys. And just in the example of the Metron case, I certainly didn't feel comfortable, and maybe some of my brothers and the sisters in the room had a different perspective, but sending stuff out saying, here's this guy, Joel Schwartz. He made so much money. He lives in a $5 million house, and he made more money than anybody else doing the same business because he cut corners on health and safety. He killed 4 people, and he's sitting in his big fat mansion with. We don't do that, right? We don't try to create because we don't want to interfere. So I'm kind of wondering how we can bring that together when there's an active case, right? And what we can do. So it's really a question for Andy.
Andy, you've been elected.
Would be this. Well, I think you described it.
Microphone.
Thank you.
Hello?
Was that making sound?
Yeah.
No, it's not mine.
If there's a BlackBerry near.
Anyways, yes, that's right. So some sort of, somebody's overhearing us. Now, let me get to the point. I think the answer is, in some cases, what you just described is the kind of thing that you do. But I am also mindful in the comment that was made is that we want to also be careful that we're not narrowing too much the scope of corporate criminal negligence, because the most pervasive and the most damaging is not necessarily the most reckless and most obvious. And so I think that while there's something to be said for that kind of strategy in certain places, Clifford Frame would be certainly one I would put on that list. I think it's always a double-edged sword because it turns the subject in a slightly different way. So I think in cases, it can be done in some cases. The other is, when it's an active case, the interference with what's going on. But I think if we, in the work that we do, if we make those connections, we put the names to the events, to the corporations. The corporation is not just the entity. It's not just XL, it's the name of the people who are part of it, and start to use those names. I think we do contribute to this recognition of the problem and put ourselves in a position to move it forward. But I think in that being said, it's a strategic choice.
Could I just make a pitch again for this idea of organizing citizens? So consumers for banks, for example, maybe now they're at, I'll join this group because they'll help me reduce my credit card interest rate, save a bit of money on service charges. But that's just where they're at now. The end point, to skip a whole bunch of stages in between, is to make people realize, who do you think financed Westray? It's a bank. So your money is being used to kill people. People don't make that connection now because they put their money in the bank, it's secure. You get your interest rate, you have your mortgage. What does the bank do with your money? That's not being thought about now. It was thought about 120 years ago in Lévis, Quebec, when the Caisse Populaire first formed, Desjardins, by Alphonse Desjardins. Not because the money was being used to kill people, but that people's money was going into the English banks, and the English banks were not lending it back to the francophones. The end point is turning banks into credit unions where we all have a say in where our money goes, not just deposit it and don't think about it. So just following classic organizing principles, start where people are at, but take them someplace else. And not enough people are exposed now, and this is a very easy way to expose millions more to what corporations are doing. again, there's no argument against it because it doesn't cost business or government anything to form these organizations. And if unions took this on here and also shared it with their international partners, because this same method of organizing citizens is applicable in almost every country in the world, even in developing countries where everyone pays their bills just through the bank because there isn't any other system, when you go to the bank to pay your bill, you could be handed a pamphlet to join the corporate watchdog group. If this was done worldwide, the capacity that would increase on the citizen side, the citizen lobby, and the citizen education side versus what is there on the corporate lobby side now and versus what is there now on the citizen education side, it would be exponential. This is the silicone chip of the citizen empowerment movement. It exponentially would increase the power of citizens
Thank
to
you,
hold
Duff.
corporations and governments accountable. So,
Penelope, you wanted to add a few words?
I think another area that we need to target is the separate legal personality of corporations when it comes to criminal liability. And the problem is amplified in the international context because you have companies that are operating, not only as separate legal persons, but also incorporated in different jurisdictions. So we need to create enterprise liability, and we need to lobby for and target this enterprise liability in the criminal context, if not in other contexts.
So I had said two questions. I'll take the third and last one from you, please.
OK, merci. Alors, mon nom est Dominique Lavoie, je suis avec l'Alliance de la fonction.
I'm with the Public Union of Canada. I was listening to yesterday what was being said, the application of the changes to the criminal code, implementation. Made me think of Machiavel. He said that you're better off to kill someone than to maim him. To make someone that would still be, you'll have more problems with someone who survives in the battlefield than someone that you will kill. And he suggests to the leaders, if you want to keep on leading, act consequently. And when you look at the principles of health and safety, death in the workplace, we have the image of the iceberg in Canada. There may be 1,000 fatalities that we are recognized as such, but there may be 1 million claims that are accepted by the commissions of work-related accidents. When Maître Bellemare spoke of the trench, the fact that there was a death, the impact or the finality on the individual is one thing, and if the objective is to improve the prevention, and we're talking about the physical, but in the workplace we know that, especially as far as 1 out of the 2 people who miss work is related to mental health issues. And there's several schools of thought that the organizations, if they're moral entities, then they have very psychiatric problems that should be looked at. So my point, and this is the question that I put to the panel, if the deaths are only the tip of the iceberg, and it's so tragic, and the experience that I have with the workplace commissions, when we're talking about compensation that was settled with Sir William Meredith in the beginning of the 1900s, let's not go there. But what we see with them, when there's money involved, more than money, they derogate from the technocratic principles, the legal principles. Yes, it is an accident. Yes, it can be compensated. When it drags on, and the absence at work is longer, when the readaptation is longer, they cower in front of this. So if I fight with someone coming out of a bar, I drank water all evening, the other guy had some booze all evening, and then we have a fight outside the bar. He's drunk and I'm not drunk, and I inflict measures. He's not dead, but the police will intervene, and I'll end up with a sentence. It seems like the approach that we have is based on the fatalities, and I do understand the importance of this, but do we want to obtain success on the practical? The law is there. Wouldn't there be any place? I think Mr. Brassaro was referred to the point of the end of the funnel. Should the CSSD or the other commissions throughout the country could I wonder, should there not be, should we use situations of fatalities to use the clauses of C-45, or could we not go with small successes that would have the effect? The first years of implementation of this law, people were afraid, and now we saw an impact, and people invested in looking at these aspects. If we go with smaller, where the judges inflict smaller convictions without being a life sentence, could be smaller things. Maybe we would obtain smaller successes on which we could build, but it would have an influence in the managing and decision-making in organizational-wise. They control the tools of work, the resources, and that's my question.
Permettre à Maître Bellemare.
I'll let Maître Bellemare answer if he wants to. Yes, you're completely right. A while ago, I heard the panelists say that it's true that C-45 is criminal law, and very often we have budget problems to work on trials through the Crown. It's hard to produce evidence. There are professional secrets that can't be penetrated, and the Crown says is that we can't prosecute employees. It's too complicated. Somebody hits somebody else. It's very easy, and there is harm, there are injuries, and we can get a medical file, and it's very easy. We can do the same thing with C-45, but in some cases it's difficult, but that doesn't excuse the fact that we never prosecute in simple causes.
Les cas simples.
Very simple, easy cases. A worker in a small company with 5 employees, there's an accident, an injury, or death. It's easy. There's an inquiry, there are pictures, there are witnesses, and we can easily prosecute. It could be taken care of in 2 hours. What's important in this is to prosecute in these small cases and develop jurisprudence, because legal principles are the same. We'll have a decision, and a judge will have to be able to think about the scope of C-45. What are the circumstances necessary for a conviction, and what kind of sentences will we have? And we'll have jurisprudence over the years, and we'll be able to go after the bigger fish like that. But in these very simple, small cases, and when there's an inquiry report, they don't intervene, and that's what makes me sick to my stomach. And we always have arguments from the Crown not to react. The lady said that we have to put pressure on the general prosecutors in the provinces. It's right. We have to do that, but we shouldn't always refer to complicated cases, poison, with systemic long-term illnesses where it's very difficult to produce evidence. Let's work with simple cases and enforce C-45. And we'll have plenty of cases here. They're very small cases, but we'd have rapid results, and we would be able to create real pressure on employers who are playing with the lives of workers, so that we have real cases. They would be covered by the media. They would be more spectacular. We'd see that in our current events. We don't see that anymore. What we see now is a worker who died on the workplace, 2 or 3 lines, maybe a little photo with a broken platform or something. We don't know anything more about what happens. But if there were criminal decisions from a court, I think that would be able to create a kind of atmosphere of fear with the employers, so that Minister Cochon had often talked about when he introduced C-45. That's what we have to expect from smaller cases. That's my theory. A very easy small case makes a lot of process with regard to C-45, and that's what we have to hope for.
To take one last question from someone who's participating online. So I'll read the question out to you. I haven't read it yet, but it was pointed out to me by Stephen Biddle, and perhaps so that we can put an end to this panel, although fascinating as it is, we have to move on to the wrap-up, and I know people are anxious to get to their other commitments. So perhaps, Andy, I can tell you right now that I'm going to ask you to respond briefly to this question. So it reads, a recurring theme in my past work with victims and families in cases with Occupational Health and Safety Act charges has been the necessity of holding individuals with decision-making authority accountable. As Mark commented, corporations have loads of money and fines are easily reduced to a cost of doing business. I would add that on-site auditors and other agreements to clean up workplace practices look like punishing a company by ensuring that they will do what they should be doing anyway. This discounts the crime of maiming or killing a specific human individual. To what extent does focus on the criminality of the corporate entity detract attention from the actual decision makers, and how can they, and not just the lowest level of management, be brought to justice?
Isn't that a small question to end
To
the session
respond
on?
to briefly.
Well, I think the brief answer is, and I think it was alluded to in Andrea's earlier question, is that we should in fact be looking at the decision makers. That is a key part of the strategy. And I would argue that although the legislation, the amendments, the corporate criminal negligence amendments, seem to focus more on the prosecution of the corporation, they have opened the door to the potential for prosecuting managers who fail to carry out their duties. I mean, I think that's inherent in the way in which the definition of corporate or organizational responsibility is now written, and it's certainly key to the duty that's in Section 217.1. And so I think it's doable, but it's of course subject to the overall conversation we've had. And but it does put the face on it. And the one piece of evidence, I did the research for the final brief the steelworkers did to the committee as part of the process. And the only place I could find any evidence of a study that had done on what would have the most impact on managers to prevent health and safety was actually work I think it was Andrew Hopkins did in Australia many, many years ago. And the answer is what you would expect it to be. Hold them personally liable.
Thank you, Andy. So it's time to let this panel go and to thank them for sharing their views and insights today. So please join me in thanking them. So Catherine and Stephen will come up and do the wrap-up.
Merci, Gabrielle. I'm going to do a synthesis.
Thank you, Gabrielle.
Avec des excuses de la part des camarades du Québec.
Et je m'excuse auprès des camarades du Québec et de la France.
Spoken in English and it came out in English, so that if you want this to be quick, then it has to be in English. I have 6 points, and I know that Steve has a couple of others afterwards. But I've tried to group together the themes, the cross-cutting themes, the overarching themes that came out of the speeches and the panels. First of all, and it's come out pretty well everywhere, is the question of normalisation of conventionalism. And it struck me when I was translating Richard's piece, and I was in England, and I was saying, what is this conventionalism? Never heard of it, right? And this is great. And everybody looked at me like I was ignorant. And then I read his third slide that explained what it was, and I said, mais c'est la normalisation de Mattei, because in France, it's exactly the same literature. And essentially what we're talking about in the history of workers' compensation legislation is that by adopting la loi sur les accidents de travail, workers' compensation legislation, business could factor into the cost of doing business, the cost of accidents. And that was the process by which this became so normal. And everybody has raised it in one form or another, that everybody takes it for granted what it's an accident. I won't belabor this point. Some people actually honestly talked about true crime. It's not really a true crime, not really a real crime. We heard that from the business panel yesterday. I would point out,
within the logic of this is that there is the business case that needs to be made in a North American context. And Ken Gell pointed this out, where he said it's easier to pay the fine than to put up guardrails, and that's what we have to be attacking. When we compare France and Quebec, when you're talking about asbestos, well, in the use of asbestos in France is a faute inexcusable that gives rise to exemplary damages. Ms. Benmar has importantly pointed out that now the Quebec government is not going to fund the continuation of the asbestos mines, but there is discussion that we're going to give money to the asbestos mines for the damages they're suffering by the fact that they have to close down. So these are two different political contexts, and I think we must remember that. The final element in relation to that first point, I don't want Harry's point to be forgotten. What gets normalized, I hope I got the quote right, one of the parties hurts is normalized, but not the other. It's the workers' suffering that is normalized, but not any kind of suffering of the employer. Second point, and there's a few sub-points, are points that came out about administrative organization versus the police. Should we have the ministries of labor and the legislation, the health and safety legislation, or should we have the police looking into these things, and what are the issues involved in that? Important point that came out of Steve Toom's presentation, health and safety executives looks for a cause, not a criminal. And Robert Bronsard in Quebec said the same thing. That the role is different. If you're looking in statutory legislation, you're not looking for criminals, you're looking for causes, and we need both. The police, if there's no obvious crime, they go away. And one of the suggestions that came out, which I think is important to underline, is the idea that we have a clearinghouse. I think it was Robert Bronsard who said this, where be it the coroners who are doing investigations, be it the health and safety institutions, or be it the police, that at one point they all end up on the same desk, and there's somebody who is looking at the overview of this. A second theme within this theme of the administrative organizations versus the police is the question as to whether provincial legislation, if you're in Canada on health and safety, or in Australia, state legislation, can raise the bar high enough to be dissuasive. And I think it's really important to underline the disparities in the sentencing between the different jurisdictions that are involved in this conference. There's no possibility of any kind of imprisonment in the provincial legislation in Quebec, and the highest possible fine for a first offense for a corporation in the case of a death of a worker is $60,000. This is not what's going on even in English Canada, and of course it's nothing in comparison with what we're hearing even in the common law jurisdictions, and of course it's not the 500 million euros of damages that have just been ordered in Europe, in Italy. Regulatory authorities can compel witnesses. I think that was an important point that came out, whereas the police can't. I think we need to not forget that. Third point is the question of special legal entities, and there's two facets to this. One that came up over and over again are, do we need special prosecutors? And this comes out in different jurisdictions. It was praised in Italy, and it's very interesting what's happened in terms of the special prosecutors in Italy, but many of the jurisdictions discussed here as well were talking about special prosecutors. There's a downside to that, and Nina brought it out yesterday from the BC Fed, which is it depends who you get, because if you get a really trivializing special prosecutor, then you're going to get really bad justice, so that you're putting all your eggs in a basket, and then it really depends on who's running the basket, if you get my analogy. The second issue that I just added after today's deliberations in relation to these specialized tribunals or specialized legal strategies is the huge contrast between what's going on in Europe and what's going on in the common law countries. And this, I wrote this down when I heard Barb's question, which is, how do you get the evidence? And basically, you, as a law firm in Europe, can survive defending victims. You can't survive, except for Ms. Benmar and a few very courageous law firms in Quebec, you can't survive defending victims in our systems. There are no common law damages, there are no civil parties, so that you can't accumulate the knowledge in a law firm that is highly specialized. I won't belabor that point, but I think it's a huge point that makes a huge difference between what's going on in François' firm and the types of realities of the people I know who represent injured workers in Canada. Fourth point is to draw your attention to the question I raised in the beginning, is who can be charged, both legally and practically. And this came out in a broad range of the presentations. In terms of legally, the Australian and the UK models don't go after unions. Coming from Quebec and hearing that as soon as C-45 came out, there was emphasis given in the training by employers, we'll get you as well and your responsibility as unions if you are going to try and raise charges in relation to us, because C-45 could conceivably justify charges against unions. It can also be used against individuals in a different way depending on which jurisdiction you are. And as Harry raised, what about the shareholders? Are any jurisdictions targeting them, and if no, not, why not? And also, Harry's underlined, why is it that the Canadian model sort of makes profit disappear as an issue? And I think that is an important issue as well. No individual liability for directors in the UK. Other jurisdictions, as we've seen, not only have individual liability, but are sending people to jail. And what came out over and over again, and has just come out again, is that it's a lot easier to target small enterprises than to target big ones. And I think we have to think about that and the social and political implications of that. And then I wrote something in French I can't read. A final point on this, on who gets charged, and the question of what's going on in France, which really the corporate organization and the organization of work that is making these large corporations and the people at the top of them liable, it's a structural responsibility. And I think that it's a model for us all to try to figure out how we can have a structural responsibility, and how does that juxtapose to the strategy of demonizing? Because if you're demonizing this nasty little guy, it might work in the short term, but that's not going to solve the problem if the problems are structural. The fifth point, how to change perceptions. We have a broad range of things. I really loved Richard's game show. For those of you who weren't here yesterday, I can't possibly describe this. So you're just going to regret not having been here. But I think that's the best cost-benefit analysis in terms of getting mindsets to change. In terms of Harry, if you start charging the shareholders, this might start making shareholders pay more attention. Céline underlined the importance of getting unions going on this, the union perspective, looking at our own practices as trade unions. The example of the plain language guide that the Ontario Federation of Labour has provided in the Kill a Worker, Go to Jail campaign, I think is interesting. The CLC pamphlet that Andy and Corey put together, and that we could perhaps in Quebec do better uptake with this and start organizing. I mean, far from me to, c'est pas à moi de vous dire comment vous organisez, mais
I shouldn't be telling you how to organize in Quebec, but if the police had them, it would be great.
So I'm just passing that on. And then we've got to lobby for more resources for prosecutions, because there's a money problem here that was raised in many of the panels, and we have to denormalize. I didn't think that was English, but Andy said it, so must be. And the contributions of the victims' families to contradict the idea of the inevitable, this is part of doing business, this is part of going to work. So my final point is really Vern, and really Vern Thériault and the way he brought forward to us the really key issues as to why we all need to make this work better. And each from our own perspective. Andy reiterated this at the end, but I think Vern really said it the best last night. After we heard what you had to say, we all have to go back and do something. And I'm really appreciative of you coming forward and helping us with that. Andy has said that the corporate criminal negligence is perhaps the new term we're going to use, and that was a very interesting point that Mitt Bernard came out. If we keep calling it the Westray Bill, we're looking for another mine. So I think that's a key point as well that is going to help us do things about this. And thinking strategically into corporate criminal negligence and building alliances, I think that would close my synthesis in relation to what Andy was saying at the end, and then I leave the floor to Steve to add his points. C'est correct? I did that quickly. I don't know if the translation worked.
It's been very patient. My role here is just basically to thank everybody for being here. In particular, all of those who came from all different parts of the world, all different parts of the country, taking the very busy time out of your schedule to be here to contribute to this discussion is, I know, greatly appreciated on our part, and we thank you sincerely for that. The only thing I want to just basically add to what Catherine has already said, her very great summary of the last day and a half, is that the Westray bill in the form of corporate criminal negligence does give us a new way to speak about and to address corporate harm and wrongdoing. And in that respect, it is more than just a symbolic value. It is a new way to speak of these harms, and it made it possible for us to be here today, or the last day and a half, to talk about these issues, and to, again, to use Andy's analogy, to move things forward however far that is. We have no way of knowing to the extent to which the little things that we all do as part of our struggles to make workplaces safer can make the difference that we reach a tipping point where, as we've talked about over the last day and a half, workers can finally stop dying for a living. The other thing I would like to add is just, in building on Harry Glasbeck's point, is the importance of addressing this larger issue of the profit imperative. I think we could have stood here for the last day and a half and talked about how corporations have made insane amounts of money, boards of directors and executives have taken the surplus values from workers and have done not a lot of good with it and caused a lot of harm. So I think there is an important element for us to realize that, as people have talked about over the last day and a half, it's not just about the bad apples, again, to paraphrase Harry Glasbeck, but also that there's something seriously rotten with the barrel itself. And we need to start raising questions about changing this kind of profit-making mentality that characterizes much of our society as one of the kind of significant factors that is behind serious injury and death in the workplace. And so there's an element here for us to also capitalize on this, to democratize what goes on in workplaces, for workers to be able to control what they do in their workplaces in better and more systemic ways. For them to start for us to not just pass along again this surplus profits to the corporations that don't always take workplace safety seriously. Okay, but enough of that for now. And again, I really want to thank everybody for being here. I'd like to thank all the co-sponsors of this event in particular that are listed in your program that have made this possible. What we would really like to leave you with as the organizing committee today is that we don't want this conversation to stop here. One of the things that we talked about quite extensively in our organizing meetings was that we didn't want this to be a typical kind of conference where everybody came and said their piece and then went home and did their own little thing. So on our part, for us to try to keep this conversation going, we have the Westray website that is going to continue to be up and is going to continue to provide a forum for us to post information about corporate criminal negligence, about these issues as they come forward. There will be a report that comes out of the symposium based on what Catherine and others have said that summarizes what was discussed here over the last day and a half. And that will go onto our website. We do have, I am a techno peasant in many respects, but our website does have a Twitter account. And we are trying to build on that social media aspect of things so that we can stay connected, even though we're all very busy in our individual worlds, so that we can keep each other abreast of the things that we are all doing individually, so that we can continue to build on this momentum. There's also a special edition of a journal that we're working on that comes out of the symposium, the journal called Policy and Practice in Health and Safety, where many of the papers that were given here will be published, and again, to keep that conversation moving forward. And we're working on also having the papers published in French as well, so we can have them available in both official languages. Other than that, again, I just want to say on behalf of the organizing committee, thanks so much for being here, and we look forward to staying in touch with everybody. Thank you very much.